ready to proceed. Talking with Mr. Griffith, though, we're going to have some properties that I'll probably have to
Mr. Griffith, outside?
He was.
I'll check. Okay.
Like yesterday, I assume he'll be back sometime soon.
Mr. Griffith is in the courtroom for the record. Okay, so who wants to start off?
Wendy, Jennifer first.
Where we're at, Judge, the defense provided an Excel sheet this morning before lunch and a PowerPoint. I've reviewed the PowerPoint and I don't have any objections except for the last page where it talks about one of Ms. Zuleger's lab validations. It was an experiment they did, and it's not peer reviewed. It's not done under any kind of efficiency test. It's not published. It's not done in a sterile environment. It's not done according to Dalbert and Fry, I would imagine. I believe it was kept out in Santa Rosa in a case over there. Either way, Ms. Zuleger did indicate that she has some peer-reviewed material that she can testify to make the same point. And obviously, we wouldn't have that same objection for those items. But we would like that portion out of the PowerPoint.
What's the substance of it?
It has to do, go ahead.
It has to do with transfer DNA, Judge. And I'm just reading from the PowerPoint. During one of our lab's validations, we investigated transfer DNA and found that if my computer, mouse, or phone were used by another biologist, keeping up, then that person touched a sterilized door handle, then my profile would show up as a minor donor every time the handle was swabbed.
Are you finished?
Yes.
Well,
Martin? Okay, go ahead.
I mean, we've already talked about transfer DNA. She's just going to give an anecdotal account of it having happened under one situation.
Right. Well, the details of it are, she's having somebody grab the mouse or the door handle for 30 seconds, which is, obviously different than what normal use would be.
Instead of twisting and rubbing.
Right.
We just have her testify to what it was, and then we'll have it down exactly.
Sure.
Raise your right hand, please. You swear or affirm the testimony you give the true self you got?
I do.
State your full name for the court and call your last name for the court reporter, please.
Candy Zuleger, Z-U-L-E-G-E-R.
Ms. Zuleger, in your laboratory, did you do I guess experiments might not be the right word, but did you do an experiment to make a determination about transfer DNA?
Yes, part of the validation before you go online with a certain DNA testing kit or a new instrument, you have to see how all the testing performs in your hands. So one of the testings that we did was a secondary transfer, just to find out how frequently this occurs, how realistic this is, just so we're able to talk about it from experience versus just looking at the literature. The literature already suggested that secondary transfer occurs very frequently, and that's basically what our conclusions were also.
And can you tell the court how you went about doing that?
Specifically, my mouse and my phone in separate instances were handled by another person. That person just touched a sterilized doorknob, and that doorknob was then swabbed for DNA, and that DNA was checked. And what it was is the DNA would transfer, was detected every time. Now, my profile was not a major donor, it was a minor donor, but it was detected every time.
And was this done for an article or for any type of peer review, or was it done in-house?
I don't think it needs to be a peer review, just an example.
That's our position, Judge.
I mean, I don't see just kind of common sense. I mean, if someone used the same glass for a long time, like you use a mouse for a long time, a mouse is going to be covered with your DNA.
Correct.
So therefore, if someone touches it, they're much more likely to pick up DNA from a personal item like that versus something someone doesn't touch often. But if you're like your steering wheel, probably has DNA all over it. It'd be
Correct.
easier to transfer that than if I picked up a book there once. That's just kind of common sense, I guess. I don't think it's more of a study, it's just kind of an example of how DNA gets transferred. I mean, but go ahead, Mr. Myers, do you have anything?
Is that on there? Oh,
Does it give any percentages or likelihoods?
on this.
Because that, of course, would depend on the 1,000 different variables.
Go ahead, answer that.
It does depend on a lot of variables, but in our testing on all the samples, the person who never touched the item, actually, their DNA was detected. My DNA was every time from those high DNA items.
Yeah, for a high DNA item.
Correct.
You're basically dipping your hand in DNA almost. Well, it's just kind of demonstrative of how transferred DNA works, but
Well, if it's stated or phrased in a way that this is an absolute, I mean, then that obviously expert's opinion, that needs to be based on a peer-reviewed science. I mean, it has to be validated, there has to be procedures, protocols put into place to make sure it's validated. She hasn't even testified as to how many times it was done.
well, I understand, but your witness already testified you had transferred DNA. And each time it's touched, the chances of showing up are greatly reduced, which makes sense.
Right.
If I'm painting a wall and I get some paint on my hand, I can put it on something. The likelihood of someone else coming in and transferring that paint to somewhere else is greatly reduced. But if the wall's all a bunch of wet paint, there's a good chance I'm going to pick some up and transfer it by leaning against it.
Why is that point not permitted through peer-reviewed examples? That's where I'm hung up at. It's something that's been studied and peer-reviewed by experts in this field, and she can make the same point, the same argument, through something that's been validated and peer-reviewed, not something she did at home or in her office.
I mean, frankly, the example that she gives is pretty unique. A personal mouse compared to, but I just see that the experts all through the trial have given anecdotal examples of how something works. Let's say, you know, decedent is covered with whatever, and temperature changes.
And the difference is, this is not anecdotal. This is something specific that she did. This is a test that she did, a test that should have been validated and done with peer review.
Well, she's not.
If she said generally, if when you touch something, you can leave DNA, transfer DNA. We've already heard that. We know. That's anecdotal. If I'm touching this podium, if I'm touching this desk, and then somebody comes behind, anecdotal. Not a specific test that she's run.
Is she going to give an opinion, or is it just an example of how DNA is
An
transferred?
example of how DNA is transferred. And that in her laboratory, because she read the literature about it, they did an experiment where
We just ran the test.
they ran a test to see if that, what they did in their laboratory supported the literature.
Correct.
I mean, I'm sure it depends on how moist your hand was. If it had been a brand new mouse and someone had touched it once, the odds of transferring are probably much less.
Exactly.
I don't see it as a study. It's just an example, like the experts give pretty much all the time, to try to crystallize it to a jury so they understand how their science speech translates to plain English.
Right, but we wouldn't be able to put an expert on to give an unvalidated experiment or an unvalidated test that was not from an accreditation, was not from a peer review standpoint, was not in some way valid under the scientific methods of that industry, for lack of a better term, or field. What we're allowing her to do is talk about something and the court phrased it anecdotally. I think if that's all it was, she could testify to that. But she's talking about a specific test that she ran under unsupervised or accredited standards, which would not meet the threshold of opinion testimony.
It's not really opinion, she's just telling you what happened.
Her opinion is my DNA's on there every time I run the test.
Every time they did in that circumstance.
Right. That's her opinion.
Of course, we don't have any personal computer mice in this case.
Exactly.
So, there-
But
well,
she she validated it by testing for the DNA. So it's not just her opinion that's there. They validated on those instances, it really was there. It's not, she's not saying it's my opinion it's going to be there. They validated the fact that it was there.
well, I thought that's kind of self-evident. You can't get opinions, you gotta have some real-world, physical events before it gets developed into a theory. Just like a fingerprint person could say, yeah, I put my fingers on a brick and then try to get a print off and you can't get it from a brick. But I put it on a piece of glass and you could every time. Just as an example of what's good surface for fingerprint capture and what isn't. But anything else? As long as it's not presented to present the 100% in that situation, there'd be no basis to apply it in a particular situation here unless the controls are the same. Would be any scientific basis to say because it happened 100% with a personal mouse that basically one person used for months, years, or whatever, versus some item that may have been touched by somebody occasionally or once or whatever, as long as it's not given an opinion that it's always done no matter what the environmental or secondary conditions are. So, Mr. Griffith, you're not going to present it to argue it happens every time.
No, sir.
Just say it can happen, and here's an example. Anything else?
No.
I'm inclined to allow it if it's just kind of an example type of explanation.
And I think the state has one other objection, both as to their expert and Ms. Zuleger as to the interpretation of some of the data that Ms. Wilkerson has in her file and that was provided to Ms. Zuleger yesterday. You want to?
The issue is, Judge, I apologize if you keep sitting down if you want me to stand up.
No.
Okay. Tired. The issue is FDLE is not accredited to report on kinship statistics. It takes a special accreditation. I believe it's AABB to be accredited. Ms. Wilkerson is not in a position to be able to testify to any statistics from the STR mix as to kinship and to, they're not accredited. She's not trained in it. She went through some training, and I think she said it was 3 slides in a 300-page book, and that's all the training she's had. She's run 600, I believe she testified 600-something STR mix samples since it first came out, and she's never had to apply STR mix in the statistical portion of that. And what it is looking at related individuals, and my understanding is it's for people when there are unknown siblings or unknown family members. For instance, if a defendant said, it wasn't me, it was my brother. And we didn't have this brother's DNA. We didn't have his sample. They can run in, not FDLE, but that's what this portion of the statistics is for. They can run that, and it's a figure that would say, hey, we don't know this other sibling's DNA, but here's the probability that this profile came from another family member or another sibling. and here's the value for it. Here's the weight to be given. That's not what we have in this case. In this case, we have known siblings and known standards for those siblings, and those were utilized, and therefore the statistics she reported are appropriate because she's saying this profile compared to this sibling is, here's the probability. This profile to the defendant, here's the probability, and so forth for each family member. Ms. Zuleger is not accredited either. She doesn't have a lab anymore that's active. She's never run STR mix in a lab. She went to a training last year in Tampa. January 15th through the 18th for STR mix training for 3 days. She's never testified to STR mix for the kinship statistical value. She's never run the statistics for STR mix, so she's never had to rely on this in her field. And we believe neither one of them are experts or qualified enough to testify to that. And so we would move to exclude any testimony about it.
STR mix is a testing method?
Is a
Software.
software for the statistical portion.
That's what Ms. Wilkerson testified to yesterday. I don't know if you recall, Judge, but in June, she had run it on a different software program. Then, I believe in August, she ran it on the STR mix program. And when I was questioning her yesterday, the results she gave were for unrelated individuals. And I asked her if they had the STR mix for related individuals, which is what the Smiths and Mr. Hartung wanted. And she said, I don't have it, and that the Florida Department of Law Enforcement, I guess they accredit it or they verify the STR mix for unrelated individuals, but they haven't accredited or authorized the STR mix portion of the software program for related individuals. But in her case notes or case file, she has those statistics. But she is not, as I understand from the state, comfortable with relating what those statistics are to the jury. But they have those.
You're saying the FDLE expert is not comfortable?
That's what I understand from Mr. Myers.
I'm not talking about comfort, I'm talking about qualified. She's not accredited. She's not trained.
I thought this was not all that high-level stuff, deciding genetic comparisons between family members. But I'm not even understanding the difference between whatever conclusion y'all are getting at. Ms. What was her name again? Wilkerson. Gave some odds, 8 million to 1, 1 billion to 1, whatever, of certain mixtures maybe having Mr. Hartung as a minor contributor versus being some random person, something like that.
And it substantially changes and lowers that value when they run it on the program of them being related. Substantially lowers.
I'm going to have a class on this and someone explain. I imagine it's explainable, because if it's not explainable to me, it's not going to be explainable to the jury, because I don't understand the concept, why it would be different, and how you would have these DNA mixtures and you wouldn't be able to, why this new program would make a difference in the result unless it's more sensitive.
It makes a difference in the result, as I understand, Judge, because the old program did 15 markers and the new program does 21 markers. That's why there's a difference in the results from the old program and the new program.
But you're distinguishing between this related component and random or unrelated component. I don't know the substance of that difference? I don't even understand.
May I take some testimony?
Sure.
Ma'am, if you would state your full name for the court, spell your last name for the court report.
Candy Zuleger, Z-U-L-E-G-E-R.
And Ms. Zuleger, what is your background as far,
I don't need your expertise, just
Okay.
explain to me the bottom line on
Okay.
this concept.
if you would, did you hear what the judge just said?
I did.
Will you do that, please?
I understand what he's asking. So in the STR mix, you get these printouts of what's called the likelihood ratio. Under this likelihood ratio, there are several designations under that. It tells you what the stats are for a sibling, a parent-child, half-siblings, a grandparent-grandchild, uncle, aunt, niece, nephew, first cousins, and then unified, which would be the unrelated individuals. So you have several options in which to choose to report, is what we're trying to get at.
I don't think experts should be testifying, they turned the machine on and here's what came out of it. If we can't understand the science behind it. I mean, the reason they can do that in DUI trials is because they go through these administrative code and they have all these statutory processes. But
Well, that's what the crux of the DNA was yesterday. The DNA samples were taken, they were put in whatever machines they use, and using the software, it gave a value that you would be a partial contributor 1 out of 7 billion, 1 out of 500 million. And that was done, testified to, as to unrelated individuals. Now, they also have, Ms. Wilkerson had in her file the results for related individuals.
what does that even mean, the results for related individuals? What do you?
Because you can run it where people are not related. You're just running it you out of everybody in the world as opposed to you out of family members.
Well, there are no more family members.
But there were at the time, because that's where the DNA came from.
Well, what kind of answer or what kind of conclusion does this give you that's different?
Ms. Zuleger?
For this first example, she quoted, I believe it was 1.9 billion. But when you look at a parent-child, that number goes down to 29,000. So it's a pretty significant difference in a related versus an unrelated statistic.
Well, I would think a good expert could show me with some graph of the basic science and the rationale. I don't want to go back to basic genetics class and biology, but as to what the concept is here, instead of just you run this different program, you get this different number.
Well, that's what was testified to yesterday. What I'm trying to do is clarify the fact that the probabilities change based upon kinship, and they're lowered based upon kinship.
Why? Conceptually, why?
Can you tell the judge why?
Just that the statistics for inclusion would be lower, and in some cases, they're actually in the inconclusive zone. So some of the statistics that were given yesterday would actually be inconclusive, couldn't be reported.
If somebody was given a TED talk on this subject, they would probably have a diagram and graphs so a layman could understand what the point is. But so far I'm understanding if you do a twist on this software in a different way, you get a different result.
No, it's not a twist. If you factor in kinship or relations, then that gives you a different result than when you don't factor in relationships. And what was testified to yesterday was not factoring relationships. And when I asked about that, Ms. Wilkerson said, we don't have that data, but they did have the data. It's just that she is not qualified to give her opinion on that data.
I'll tell you, I don't understand it. I can guarantee you this jury won't understand what we're getting at, because the best I could get from Ms. Wilkerson is that you had known DNAs from 4 people. She found some foreign DNAs occasionally on some certain items. And when she compared, when she did an analysis, she gave some conclusions about the odds of this being some evidence, Mr. Hartung being a contributor versus to the random chance of that happening in the world. And now you're saying it's the same thing, but it's going to be a different result, but I don't understand why. And I would think it really is explainable why there would be a difference.
Can you explain that to the judge?
I will try. One of the examples is one of the mixtures she detected, there was just say an 11, a 12, and a 13. She's including all 4 people. Donald's an 11-11, Voncile's an 11-12, Richard is an 11-12, and John is an 11-13. So that 11 gets counted 4 different times, but the software, she's taking that person out and doing an unrelated calculation, so the software thinks that it's just this person each time, so it's going to give a really high statistic instead of the other people actually being into that mixture. I don't know if that helps.
May I,
Yes.
Judge?
Yes.
Judge Dents for the state. Judge, that sheet that Ms. Zuleger is reading from is a document that came out of Ms. Wilkerson's file, okay? And my understanding is that the analysts don't ask for it. This program just spits it out. But the purpose of those stats is when you are in a situation where you're estimating unknown siblings. For example, like Mr. Meyer said, if I say I didn't do it, my sister did, but they don't have my sister's DNA, then they generate these estimations of what the possibility would be for a sibling.
So you're saying, for instance, when she said the 1 in 29,000, it would be the odds of this person doing it with an unknown sibling,
Yes, sir.
which is not the situation here.
Yes, Judge, and that was the whole point. It's irrelevant because Ms. Wilkerson has all DNA profiles for the siblings in this case.
So what, okay, assuming that's correct, what do you do the relevance to the case? We're not looking for unknown siblings.
Ms. Zuleger, is it only unknown siblings?
No, there's other unidentified alleles into these mixtures.
So what does that mean?
It's not just the 4 people she's reporting. There are samples that have other alleles, foreign alleles in them. And I just tried to give an example of the 11 being counted 4 different times, even though it just has the one entry into it.
So does it significantly change the probability from, say, 1 in 500 million down to 1 in 10,000?
It significantly changes it, yes.
And does it only have to be with unknown siblings?
It can be any sibling, a parent child, or a half-sibling, I don't know, grandparents.
No, the point Ms. Jensen is making is she believes the opinion is only telling the listener what the odds are of whether it's Mr. Hartung or whatever subject versus an unknown population of siblings or relatives, not versus the entire world. And if that's true, it would not be relevant to this case because the relevant statistic is the entire world or the total number, not a restricted population of possible relatives.
But it has to go with the program is saying that if there are relatives, it is a lower number when you factor in these people as being relatives as opposed to being an unknown population.
Let me tell you where I think I understand so far. And anybody can tell me I'm wrong. That Ms. Wilkinson's number was Mr. Hartung against the world, and Ms. Zuleger's number is Mr. Hartung versus a theoretical relative.
Is that correct?
I think so.
So if you would have had a population where only relatives of Mr. Hartung existed, then that would be a relevant number. But that's not the world. Assuming my comprehension is correct at this point.
Judge, Ms. Wilkerson is seated behind me, and she said you're almost there. But it's actually Mr. Hartung's unknown related sibling against the world, not Mr.
Okay,
Hartung.
so not him against his unknown siblings, but all the unknown siblings that could be against the world.
She's nodding her head yes.
She's nodding yes, which is not at all the situation. And falsely amplifies one component of the results. Again, I'm speaking based on about 10 minutes of discussion, so anyone can correct me if they want.
Judge, I think the only thing that the state would add, I mean, I'll do to Ms. Zuleger, but as Mr. Myers already said, our expert has actually run samples, 600 samples. She has worked samples. She's had training in it. Their lab is accredited. Ms. Zuleger has been to a training session. So her ability to even speak on these results that are generated in a file that Ms. Wilkerson can't even speak to. Again, our position is that she's not qualified to do so.
Well, really, it sounds like your expert could actually give an opinion, a science-based opinion. She's just not, quote, certified in it. But I think anybody who probably has a thorough understanding of genetics and DNA could probably explain it. They may not be certified or qualified as a witness, but they may be a good science teacher. So I just need like the 8th grade level science teacher. But so far, it doesn't sound like it's close to being admissible because it's not the same comparison. State's witness says you're talking about comparing all the unknown siblings to the world versus just Mr. Hartung to the world. And of course that greatly reduces the ratio of odds because you've got, I don't know, how many theoretical unknown relatives? Probably a whole bunch. If you want to take a break and sit and talk about it to see if I'm missing something.
One other issue, aside from this. Roddenbery.
Sure.
I'm intended to call Mr. Roddenbery back for the purpose of asking, he said in his testimony that Mr. Hartung would inherit, and this is what he's talking about at the time the wills were made, if everyone had been deceased. And I wanted to call him back to ask him that even now it was established that Mr. Hartung would inherit based on the probate that's been filed if he is to be acquitted. If he is to be convicted, then his son will inherit.
I don't think it's a criminal standard, is
Yeah.
it? Is it a criminal standard?
Yes, sir.
What do you mean? I'm sorry.
In the statutes prohibiting,
Yes, there's a Slayer statute.
Yes, sir.
Which is going to prohibit Mr. Hartung from inheriting the Smith estate if he's convicted.
it requires a conviction.
Yes, sir.
So there's no civil standard involved.
Yes, sir.
That's correct. But at the time that the will was executed, there was no way of knowing whether Richard or John had wills, and I was going to have him testify that wasn't predetermined that if everyone died at that time, Mr. Hartung would inherit. It would depend on whether John or Richard had a will. The implication is that my client knew if he killed everybody, he would inherit. And that's not necessarily true, because if John or Richard had a will, then their estates would go to the beneficiaries of their will.
I mean, they left it to someone because they don't have children.
Correct. If they could have written in, we want to give it to the Waterfront Mission, and then it would all go there, and Mr. Hartung would not have inherited. But the case was, apparently they didn't have a will, but at the time that all of this took place, there was no way of knowing that. So, and I just want, I want to put him on to verify that if I argue that I'm not just making it up.
Are you also going to remind him not to keep talking after his testimony's through?
I will let you do that, Your Honor.
Well, I don't know. When I do it, it's too late sometimes. I mean, he was on.
Yes, yes,
Good intentions, but after a minute, when he stopped, he started just talking to the.
I will handle that, Your Honor.
But Judge, I guess, again, the state's position is, what is the relevance of whether John or Richard had some will or didn't have a will? I mean, I don't know that he knows the answer to that.
Well, he's not going to argue anything. Mr. Griffith would argue it lowers the motive to some degree.
That they had wills?
If they had wills, then it wouldn't be guaranteed that Mr. Hartung would get the estate if everyone else passed. That's a matter of argument.
And that's what I'm going to put him on for, Judge, for that purpose.
You didn't touch on something like that already?
No, sir.
Okay, that's fine. But are we through talking about what Ms. Zuleger, am I pronouncing your name correctly?
You are, yes.
Yes, if I could talk to her outside for a moment, then I think we're good to go.
And who will be your next witness?
I'm going to have Mr. Roddenbery come in. He left his office to come in, so.
Anything else on Mr. Roddenbery?
No, sir.
Okay. Mr. Roddenberry, you have a seat. They'll call you to the stand in just a second.
Should I just leave this up here then?
Judge back, please be seated. And Mr. Griffith, you may proceed.
Judge, at this time, the state will introduce a thumb drive that contains the entire interviews of Mr. Hartung, and that would be Defense Exhibit 26. My understanding is Mr. Myers has no objection.
Right, and that's defense exhibit.
Defense Exhibit 26.
No objection.
So admitted.
And we are not going to publish it at this time.
Very good.
Mr. Roddenbery?
Good afternoon, sir. You can be seated. You've been previously sworn.
Okay, thank you.
If you would, sir, please state your full name for the jury and spell your last name for the court reporter.
My full name is Seaborn Anderson Roddenbery, Jr.
And you're the same Mr. Roddenbery that testified last Friday, is that
Yes,
correct?
that is correct.
Now, one thing I wanted to clarify is that at this point in time, Mr. Hartung is in the position of inheriting the estate of his mother and two brothers, is that correct?
That is correct. He is the sole heir at law.
Okay. Now, that is because, as we now know, that no wills for John or Richard R.T. have been found, is that correct?
That is correct. I'm not aware of any wills that they ever did.
Okay. Had they done a will, each of them had a will, if they did, then the proceeds of their estates would have gone to whomever they designated in their will, is that correct?
Possibly so. It depends on the will. If someone is married, their wife has certain legal rights. If they have children, they have certain legal
Okay.
rights. And since they did not, they could leave the will to whomever they wanted to. They could do a last will and testament. And
Okay.
the will,
Wait a minute, let me just ask you. We know that neither Richard nor John were married.
they were both single, no children.
Right. So whomever they would have left their estates to, that's the person that would have received the proceeds of their estate.
If they leave a will, the will would have to be valid in order to pass to somebody, but they could leave it to, theoretically, to whoever they wanted to. It wouldn't have to go to any family member.
So you can exclude a family member by a will.
Yes, you can.
And in 2015, you did not know whether they had a will or not,
I did not know, and as far as I know, they never had a will.
but you don't know one way or the other,
You know, I do not.
and you did not know then.
You
You know now that they didn't.
No, I did meet RT when he came in one time, but with his mother. But other than that, I've never met John.
Okay. And you wouldn't know if they may have used another attorney besides you.
I would not know.
Okay. Thank you, sir. I don't have anything further.
Hello.
Hello.
Mr. Roddenbery, you are not aware of any will that John Smith or Richard Smith had, correct?
That is correct.
Okay, so if John Smith and Richard Smith die without a will, what happens?
Well, if they have no wife, no children, and they die without a will, it goes up to mom and dad.
Okay, mom and dad are
Okay,
dead.
Dad had died in 2012, about 2 years after Dad and Mom did the will in my office. That was January 9 of 2009, I think it was. I've got to go back. Yeah, January 9, 2009. So it would go back to wherever it was at that time. And at that time, they basically everything would have gone up the line. When either one of them died, it would go up to Mom because Dad had already died.
Okay, and then mom we know is deceased, so then where does it go?
Well, if Mom was deceased at the same time that RT and John were deceased, then it would go to the living heir at law,
And who's the living heir at law?
the defendant here,
Thank you, sir.
Donald Hartung.
Thank you very much.
Anything else?
No.
Thank you, sir.
Thank you. Can I just say one
No,
thing?
no, sir, no, sir, no, sir, no, sir, you can't, I'm sorry. Mr. Griffith, call your next witness, please. Good afternoon. Would you raise your right hand, please? Do you swear or affirm the testimony you give be the true self you got?
I do.
Thank you. Please be seated.
Ma'am, if you would, please state your full name for the court and spell your last name for the court reporter.
Candy Lynn Zuleger, Zuleger.
Ms. Zuleger, what is your profession?
Profession is forensic DNA analysis. I'm currently a consultant for forensic DNA testing.
And did I retain you to look at some DNA material
Yes, you did.
in the case of State of Florida versus Donald Wayne Hartung?
Yes, I believe it was around November of 18.
Okay. And are you being paid through the Judicial Administrative Commission?
I am.
And what is your hourly rate?
It's $200 an hour for out of court to review documents and $240 an hour for testimony.
And you've not been paid anything so far?
There was one invoice that went out for $5,000 last summer.
And that is through the state that you're paid, is that correct?
Correct.
Now, what is your educational and professional background?
I have a Bachelor of Science degree in biology, a Master of Science degree in cellular and molecular biology with a thesis. I started my career in forensic DNA with the Florida Department of Law Enforcement. I worked there as it's called a crime laboratory analyst, but I performed forensic serology and DNA testing. I started the private laboratory of Trinity DNA Solutions. I was there for almost 15 years. As the laboratory director, did the same sort of testing. And in the end of 2018, sold the lab, and I've been a consultant since then.
How long did you work for the Florida Department of Law Enforcement?
I was there almost 8 years.
And then you opened your own laboratory, is that correct?
Correct.
Have you testified as to DNA in any courts in the state of Florida?
All the circuit courts in the state of Florida, military court and federal courts, and some other states and jurisdictions.
Now, what I wanted to talk to you about today was transfer DNA. Can you explain to the jury what transfer DNA is?
Transfer DNA isn't necessarily a direct contact. That means, or a secondary transfer. Obviously, you can make a direct contact with an item. That's going to be a primary transfer. And then there can be a secondary and a tertiary level transfer. So an example I use is in our laboratory, we tested a computer mouse and a phone, a landline phone, something with high DNA on it. So if another analyst took my computer mouse, used it for 30 seconds, and then touched a sterilized doorknob, so we swapped it for DNA, took it through the process, and we were able to see that my DNA transferred, even though I never touched that item. So this isn't a new issue. It's very well documented in the DNA literature that secondary transfer and tertiary transfer occurs.
So it's not a reckless theory. It's a well-established theory.
It's well established. It's not theory. It happens.
Now, can two items rubbing against one another cause a transfer of DNA?
Yes, it can. And I will say that more DNA will transfer if there's moisture involved. So if one of the items are damp or wet, there'll be more of a transfer to the second item if there's moisture involved.
And you've already given the example of people touching things being transferred. Could DNA be transferred from plastic gloves, such as gloves that are worn by crime scene analysts?
Definitely, yes. Again, you're touching items that have different DNA on them. Of course, you're not putting your DNA on it, but you're potentially transferring DNA from one item onto another item if you're not changing your gloves in between those exhibits. Specifically, when the evidence gets to a laboratory system, when I'm examining a piece of evidence, I use a different pair of gloves every time I examine that piece of evidence. So we go to great pains in the laboratory in order to ensure that there's no sort of contamination with other items. But if that same sort of, if those same things are not adhered to during the crime scene, then you're going to have contamination, and me or anybody else at the DNA level aren't going to be able to detect that contamination. It's just going to appear as a mixture.
So in other words, if a crime scene analyst were to pick up a piece of evidence that has DNA on it, bag it or take it into their custody, not change their gloves and pick up another piece of evidence, could the DNA from the initial piece of evidence be transferred to that second piece of evidence?
It could.
And if that were to happen in the laboratory, would you be able to pick that up? Would you realize that it was a transfer of DNA from one item to the next?
If it occurred at the crime scene, no. We have things in place in the laboratory to ensure it doesn't once it gets into the lab.
But if it happens at the crime scene, you have no way of knowing that?
I have no way to detect that, no.
And then your report would reflect just the DNA on both items, even if it was the crime scene tech that transferred it. Is that correct?
Correct. It'll just appear as a mixture to me.
Is there any way for you to be able to tell if a person picks up one item, then picks up another item, whether that DNA will transfer? You can't say for sure it's going to transfer.
I can't say for certain it will transfer there are so many different variables as to if it will transfer, if there's moisture involved, if the person sheds a lot of DNA more than others. There's a lot of variables. Correct, yes.
Because whatever DNA is put on the item will then be picked up by the gloves possibly.
It could, yes.
And that's, just don't know, is that correct?
You don't know if you're not going to change gloves.
And is that why you change gloves?
That is why we change gloves in the laboratory.
So without that safeguard at the crime scene, we don't know what's been transferred from one item to the next.
You wouldn't know.
I don't have anything further, Your Honor.
Just briefly, ma'am, how many hours have you put in so far?
I don't know, probably the past few days it's been close to 40. And I don't recall how much prior to that.
Have you reached your maximum allotted?
I believe so, yes.
And what was that?
There was a second order for 15,000.
And what was the first?
The first one was 5,000, the second one was 15,000. There should be another one for 5,000.
So 25,000 total?
Correct.
When you were talking about the transfer of DNA, every transfer, the amounts diminish. Is that accurate?
That's correct.
And when you did your test at the at your facility, and you touched on it, there's a lot of variables that go into it. How sweaty someone's hands could be, whether they had washed their hands recently. Lots of variables, correct?
There are a lot of variables,
Okay.
correct.
And I think in your situation, you had somebody touch the mouse for 30 seconds, the doorknob for 30 seconds, 30 seconds?
Correct.
Okay. And I believe, I don't know if you testified to this, but when you would find the profile, it was the minor profile.
Yeah, the minor profile was detected each time, yes,
Right.
but it was a minor profile.
You testified that if moisture was involved, it could more easily transfer.
Correct.
And by moisture, you're not talking about water.
Not necessarily.
You're
But
talking
it
more
could
like
be-
sweat, blood, saliva.
Well, when you're talking about a bodily fluid, that's going to transfer a lot easier than anything else. I'm speaking more towards epithelial cell DNA, skin cells.
Right. And I believe you testified, if contamination happens at the crime scene, you have no way of knowing it.
Correct.
Thank you, ma'am. Those are my questions.
Just briefly, Your Honor. Now, with DNA, secondary DNA or contributor DNA, are those the same things?
It depends on how you're using them. Secondary transfer means that the main DNA donor, the person who didn't touch the item, is transferring that DNA.
Okay, so you heard the testimony of Ms. Wilkerson yesterday.
Correct.
And she talked about some, transfer DNA.
Correct.
And you have your main contributor, correct? What do you
Yes,
call that person?
That's a major DNA donor.
Okay. And after the major DNA donor, what do you have?
If it's a mixture, sometimes you'll have what's called a minor DNA donor.
And are there any other types of DNA donors besides a minor and a major?
Well, you can have several minors or 2 majors. It depends on the number of donors. You can also have what's called an indistinguishable mixture, meaning all the peaks are about the same height. You can't tell a major from a minor, but you can include into that mixture.
And DNA can come in various forms, is that right?
Yes.
It can come from skin cells, blood, sweat, spit, what else? Did I cover most of them?
Pretty much, yes.
Okay. And as a crime scene analyst, you can't necessarily see DNA, is that right?
No, when we're talking about transfer DNA, you don't see that.
Well, when you're swabbing surfaces for DNA, you don't know if it's there or not, is that right?
No, we don't.
The only time you're pretty sure there's DNA is if it's like spit, that you can see it, or if it's blood, is that right?
Blood would be the easiest. In that way, you know, you're pretty much going to get a DNA profile. But yes, when you're swabbing for epithelial cell DNA, you have no idea until you run the DNA if it's there.
Okay. And is the epithelial cell DNA the easiest one to contaminate? Or you get secondary DNA from?
I think you're using different terms.
Okay. Try to correct me then.
I'll try. It's because most epithelial cell DNA profiles are low level. You're going to see a lot more low level mixtures mixed into that because the testing that we do is much more sensitive than it was previously in the previous generation. So we're picking up profiles that we never would have before. So it's more uncommon to see single source profiles these days than mixtures. Almost everything I see is a mixture.
And is that just because the software that is being used is that much better?
It's because of the DNA testing kit. It can bring up low levels of DNA. And also there is a new testing that we can do for the statistics, STR mix. It can calculate those low level contributors, their inclusion, whereas we couldn't do that previously.
It's just like everything else, everything's getting more sophisticated?
It is getting more sophisticated, yes.
I don't have anything further.
All right, nothing further. All right, thank you. You can sit down. Counsel approach. All right, members of the jury, we're going to take another break. I guarantee you it's going to be shorter than the last one. So we'll see you in just a few minutes. Yes.
How long do you need, Mike?
Okay, Ready for the jury?
Yes.
Bring the jury in, please. Jury's back, please be seated. Mr. Griffin,
Your Honor.
and you wish to renew your motion?
I do.
All right, same ruling as the previous.
Thank you, Joe.
Judge, the state has one rebuttal witness, Jennifer Wilkerson.
Good afternoon. You're still under oath, and please be seated.
Afternoon, ma'am. Can you state your name again?
Jennifer Wilkerson?
And you're employed at FDLE?
Yes.
Yesterday, you testified the filter paper that you used to test the hammer, or the hammer in the slot. You know what I'm talking about?
Yes.
I believe it was Exhibit 22D. Yesterday, you testified it was negative for blood. Is that accurate?
I believe I've testified that I didn't test it, and I did.
Okay, and what was the result?
It gave chemical indications for the presence of blood.
All right, thank you, ma'am. That's it, Judge.
Nothing further, Your Honor.
Thank you, ma'am.
State rest, Judge.
All right, members of the jury, that closes the evidence for the case. So we will recess for today and have closing arguments tomorrow morning, and then you'll deliberate after closing arguments. Do you want to start at 9 o'clock?
Sure.
It's fine, Judge. Unless you have any issues about jury instructions.
Right. Okay, so again, let me remind you not to have any contact with any information regarding this case. And hope you enjoy your afternoon. I think the weather's nice today. And please be here at 8:45 tomorrow morning. Thank you. Please be seated. All right, do you want to go over jury instructions?
Yes.
Or do you- Okay.
Please.
That might be appropriate to go ahead and get this out of the way.
Do you have an extra copy?
Oh, Judge.
That's all right. I've got it online anyway.
Okay, I'm sorry. I filed them in accordance with the court's
Yes.
order.
We're holding on.
Mr. Griffin, tell me when you're ready.
Judge, just for the court to consider overnight, you may want to take a look at Rule 3.370, and that's for the sequestration of jurors.
Okay. Mr. Griffith, do you have yours pulled up yet?
No, that's okay, Judge, go ahead. I know the initial ones.
Okay. Well, I'll wait till you get to it. If you need a printed version, we can get one printed up.
If you can get me one, Judge, I'd appreciate it. Because we can't seem to find where it was, what date it was filed.
If you could get two.
Tell you what, let me give the defense my copy, and I'll be able to find it online.
I filed them, the first time was last year, May 20th, and I filed them again on December 30th. It's a notice of filing.
I've got it.
Okay.
I don't see the notice of filing, but I don't see it attached. You said it was in June, was the fire one?
That was, May was when we were set for trial last time, Judge. The most recent was December
I got
30th.
it.
Do you have them, Judge?
Yes, I'm getting through the sentencing phase instructions.
Okay.
Okay, introduction to final instructions. Okay, page 1. Any objection? I'm asking the defense primarily. Are you looking at your computer or the paper copy?
I've got the paper copy.
Do you have any check?
No objection to 3.2.
I'm sorry, to what?
Yes.
Page 1. Page 1, which is the first paragraph of justifiable homicide, or the whole paragraph. Just to the bottom of page 1.
No objection.
Then tell me when you're good with page 2.
Judge, the problem we're having for us finding it on the internet is the state did a notice of filing, and it says jury instructions, preliminary instructions, etc., but it wasn't filed on the clerk's page, just the notice of filing is on the clerk's.
Well, they were emailed to all parties.
Yes, but in May, it is on the clerk's page. You're right, December I couldn't find it, but May it is there.
Okay,
So
thank you.
go to May 31st. You'll see a 29-page filing on May 31st.
Thank you, Judge.
Okay. So once you get to the halfway through, you get to the guilt phase instructions, and we're on page 2. And I'll stay on page 2 till the defense tells me they're okay. And of course, even if you miss something this afternoon, we can correct it in the morning.
On the part I'm looking at, on the clerk's page, it said on the bottom of page 2, comments, the court may instruct jurors regarding victim impact evidence or other sections of the final instructions, number 7.11, as part of the preliminary. That's not going to be in there.
Those are penalty phase.
That's penalty. You go further down the document. You gotta keep going to get to the
Okay.
introduction.
Page 2 is fine.
Okay. Page 3.
I'm fine with page 3.
All right, page 4.
Four is fine.
Page 5.
On 5, Judge, on my copy, it says on the second paragraph, in parents, the explanation of justifiable homicide and excusable homicide on instruction 7.1, you're not going to have that in there,
I think that would be helpful, actually.
Yes.
It directs them back, because I say it was previously instructed to you, and it tells them specifically where it was. I think it's appropriate.
Other than that objection, everything's fine on that.
Okay, so it'll be as written, page 6. Page 7. I would suggest number 6
State agrees.
is not applicable. Number 7 is not applicable.
Wait, 6 is applicable.
That, well,
Mr. Purefoy.
oh, that's correct. Page, excuse me, number 7, not applicable.
State agrees.
10 not applicable.
Agreed.
So you have 7 out, 10 out,
And the rest remain.
And then we'll just renumber.
1 through 8.
Yes, sir.
Good with page 7 yet, Mr. Griffin?
7's fine, Judge, as I understand, you're taking out 7 and 10.
Correct.
Fine.
Page 8. Take out the wording, of course, regarding the defendant testifying.
Yes, sir.
Now, is 39B applicable?
Yes, sir.
It is, Your Honor.
His 2 interviews.
Well, but is that really an issue that anyone wants to raise, the voluntariness of it? I don't know if that's going to be argued by anybody.
Judge, I put it in there because there's statements by the defendant. If
Right.
Mr. Griffith wants them, great. If not, I can take them out.
I think if he's staying, he should stay.
Okay. And then when are you otherwise good with 8?
Yes, sir.
Okay, page 9. Taking out, leaving in the defendant's statements. And we'll take out number 7 because we did not have jury questions.
Agreed.
Otherwise, it seems appropriate. Tell me, Mr. Griffith, when you're good with page 9.
I'm good with page 9.
Page 10.
Ten's fine, Judge.
All right, page 11. Are there some exhibits y'all want to automatically send back with them, or just keep everything out here? I don't think we would send everything back, because some of this evidence you would want them tampering with, bagged evidence. But photographs, and anyway, we can either keep everything out here if they want to ask, or if there's certain evidence you want them to go back with.
Judge, I would let them have everything.
I would just send back gloves.
I would send, the only thing with the gloves would be the hammers.
The hammer and the projectiles. Or the projectile jacket. But I think those are actually those aren't loose in there, they're in a plastic container.
So instruct them not to remove it from the container.
Probably.
Probably
Seriously.
don't.
I think you should all go back, but
Okay, so we'll give them some instructions not to open sealed items. Is everything else unsealed? Like the hammer, is it unsealed?
Yes, sir.
Yes, sir.
Ms. Wilkerson
Held it up.
held it up and showed it to the jury where she swabbed and tested.
What other physical items were introduced? Anything?
Just the projectile. The rest is documents like paperwork.
Okay. All right, anything else? How about verdict form?
I reviewed the judge, it was fine with
Okay, anything else? And I don't usually, go ahead.
I'm sorry. For the record, what was your exhibit number of the interview, Mr. Griffith?
that. 26, I believe.
All right, so exhibit 26, we haven't had a chance to review, we being the state, and so I'm going to copy exhibit 26 of the defense to our computer for us to have a chance to review it, make sure redactions that are appropriate have been done. And then
That's fine, Judge, and if there's a problem, we'll get together before court in the morning.
Well, Mr. Griffith, how do you think yours differs? Did you make any redactions?
There were some things initially that the state had redacted that we had agreed to. Part of it had to do with the Star Wars issue that you brought up earlier.
What issue?
It had to do with Homeland Security issues.
The Spa War.
Richard Smith's job was mentioned in the interview. The state redacted it out. Mr. Griffith is using a different recording, and so we just want to verify that our redactions are the same on his exhibit as they are on the state's.
But is Mr. Griffith's version more expansive than the state's?
Yes.
Yes.
The reason it's more expansive is it contains the video of Mr. Hartung when Agent Enfinger exited the interview.
Nothing prejudicial, but the state didn't think it was necessary for their presentation to save time for the jury.
Right, Judge, we just redacted. Anytime Enfinger left, we stopped it. When he came back, we started it. So I think there are some things maybe that they think they want the jury to see. We have no problem with that.
But it was nothing you wanted out, it was just expedient to save dead time?
Yes, sir.
Okay.
Yes.
Right, and our position is it shows some things we think the jury needs to see.
Okay. Anything else?
Not from the state.
And I don't usually set time limits on closing arguments. I mean, when the jury starts nodding off, that probably is a good clue, but y'all have been pretty efficient. I suspect your closing arguments will take as long as they need to take.
I just speak louder when they fall asleep.
Okay. All right, we'll adjourn for the day. See y'all tomorrow morning, 8:45.
Thank you, Judge.